The Supreme Court of Appeal is to hear arguments in the right to die case of the late Robin Stransham-Ford. Last year, the North Gauteng High Court ruled in favour of Stransham-Ford's application to allow a doctor to help him end his life. Our reporter Karyn Maughan is at the Supreme Court of Appeal for us this morning. Karyn, a very good morning to you. We know that the case involves the HPCSA, the Health Minister, the Justice Minister and the Director of Public Prosecutions. What exactly do they want the Supreme Court of Appeal? What are they asking for today?
Well, good morning, Uveka. Of course, Robin Stransham-Ford dying just an hour before the judge actually delivered that order that he would be allowed to commit assisted suicide with the assistance of a willing doctor, and that doctor would not face criminal charges of either murder or culpable homicide. Now, I'm joined by Karyn Maughan from the Department of Justice, Constitutional Development and Correctional Services. Karyn, what is government's stance on assisted suicide, and why did you feel it's so necessary to appeal that ruling, given that the judge was very particular about the fact that he said this ruling was only in relation to Robin Stransham-Ford?
The difficulty that the judgment presents is that it has opened an uncontrolled free-for-all window, in the sense that in as much as it's case-dependent, but it doesn't prevent applicants or patients from making use or making reference to this judgment as a benchmark moving forward. You know the rules of judicial precedence, that the previous judgment will always be used as a reference, so there's no way that we can allow that. Secondly, from an ethical point of view, you'll hear argument from the Health Professions Council of South Africa that the oath of office that a medical practitioner takes is to preserve or save lives and not to end lives. And as we stand, the judgment itself has a bearing on the constitutionally entrenched right to life, which is a right that is sacrosanct. Now, criminal law in South Africa criminalizes assisted suicide, and as such, you would be charged with murder or culpable homicide. Now, if then the judgment says the doctor who assists the patients to die will be absolved from prosecution, that has a bearing on the powers of the National Director of Public Prosecution to prosecute those people. So it has a constitutional bearing and implications which are far-reaching. That's why you say 5 judges of the Supreme Court of Appeal must ventilate this issue and have a pronouncement on it. Don't leave it to one judge. He may have erred.
Well, we've seen Archbishop Desmond Tutu come out and say that he would want the right to end his own life if he was suffering. And there's an argument that says the Constitution also upholds very sacredly the principle of dignity, that life at any cost, life when people are suffering, life when people can no longer care for themselves, life when people are just wanting to not be in constant pain and dealing with the constant indignity of a slow and lingering death, that simply wanting life at any cost cannot trump a human being's right to die in a dignified, quiet fashion, surrounded by friends, as essentially what Robin Stransham-Ford wanted.
Of importance is that it's always dangerous, Karyn, to argue or view legal issues from an emotional perspective, because the right to life is sacrosanct. Yes, there's a right to human dignity, but you're not saying to me that that right overrides the other. And it's important, therefore, that any judgment that has a bearing on the constitutionally entrenched right to life, which has been ventilated and commented upon in many cases like State versus Makwanyane. So it's important that we looked at this from a constitutional perspective point of view and from a legal point of view. Where does it put a medical practitioner's career insofar as ethics are concerned? But where does it put our legal system insofar as judges being allowed to develop the law but not to go beyond by decriminalizing an offense that is currently murder or culpable homicide?
Well, we know that Robin Stransham-Ford relied on a Law Reform Commission report that was actually handed to the Minister of Health in 1999, in which government looked at potential legal options for assisted suicide. Is there any possibility that government would consider a bill or a set of legislation around this issue that under certain constrained circumstances where people are gravely and terminally ill and in a great deal of pain, they have an ability or a legal mechanism to end their lives in a peaceful way? Is that ever something that government would consider?
At this stage, we're not considering that. At this stage, we're considering the far-reaching implications of this precedent-setting judgment.
Thank you very much, Mthunzi Maga. That was, of course, Mthunzi Maga from the Department of Justice and Constitutional Development. Crucially, Judge Fabricius, in his judgment, which was delivered last year, Uveka, asking the question of how human beings were able in so many ways or told to control the circumstances of their life, but not allowed to control the circumstances of their death. Also saying that while human beings ended their own existences or had their existences ended in a variety of terrible and horrific ways, he questioned why we were societally so reticent about enabling people to do it in circumstances where they were suffering. This is an incredibly divisive issue. It's sure to cause a lot of debate within the country, and it will be heard and ventilated in this court this morning.
It'll be very interesting to hear what comes out in court. Thanks very much. That's Karyn Maughan. She's outside the Supreme Court of Appeal, which is due to hear arguments in the right to die case of the late Robin Stransham-Ford.